Hi, good evening class. Welcome to our last lecture on the law on partnership, particularly on limited partnership. Before we formally start the discussion, for those of you who might be wondering, when I post the provisions of the law, you will notice either right after the provision, there's a parenthesis with a number in the letter A or the letter N. That only means that that provision is either an amendment of an old civil code provision, or if it's letter N, it's new. So because this civil code, the one that we're using, although it's actually it was promulgated in 1950, so matagal na, it was actually copied after the Uniform Partnership Act of the US, and in particular for this section, for limited partnership, most of the provisions would be copied from the Uniform Limited Partnership Act of the US. Although it will not be asked in the test, I think I just wanted you to know, especially for those of you who, like me, love trivia for no apparent reason. As we study limited partnership, we can easily notice that the major theme or key characteristic of a limited partnership is a lack of a limited partner's personal liability, or what we call a limited liability, in relation to the partnership. So the reason why this is so unique is because it's an exception to the general rule under Article 1816, if you remember, where all partners are liable pro rata with all their property for partnership debts. Therefore, a limited partner is actually akin to a stockholder of a corporation. Because a limited partnership is less advantageous to the third person. And I say less advantageous because that third person has less people that creditor can run after should the partnership business be at a loss. A partnership transacting business is prima facie, meaning without any evidence to the contrary, it's assumed to be a general partnership. Now, there is no perfect type of partnership, as both a general and a limited partnership has its pros and cons. We shall go through them when we compare both types according to certain criteria. Note, as we go through the similarities and differences between these two types, we will be going over the 5 characteristics of a limited partnership, particularly that of its form, management, a partner's respective contributions, instances when a return of contribution may be had, and source of payment of partnership debts. The others, I will add also like liability, the differences in terms of liabilities and rights, in terms of dissolution. So, let's start. As to composition, a general partnership, if you remember our definition under Article 1767, there are actually 2. I didn't put the second paragraph anymore. The first one is where 2 or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. Now, when it comes to a limited partnership, it's not just 2 or more persons without any distinction. A limited partnership is one formed by 2 or more persons under the provisions of the article. So, a limited partnership is from Article 1843 to 1867. Having as members 1 or more general partners and 1 or more limited partners. So that's key, that there is at least 1 general and 1 limited partner. As to partners' contribution, if you remember, under Article 1767, by the contract of partnership, they bind money, property, or industry. Whereas in a limited partnership, under Article 1845 here, the contributions of a limited partner may be cash or property but not services. Therefore, there is no such thing as an industrial limited partner. A partner who contributes services will be considered an industrial general partner. Therefore, they will be liable personally in case that the partnership assets are insufficient. No? There is actually an exception, and it's under Article 1853 here, where a person may be a general partner and a limited partner in the same partnership at the same time, provided that it should be stated in the certificate under 1844, which was in the previous slide. So what happens if a person has a dual role of a general and a limited partner? A general who is a person who is a general and also a limited partner shall have all the rights and powers and be subject to all the restrictions of a general partner, which we will discuss later when we talk about management rights and liabilities. except that in respect to his contribution, he shall have the rights against the other members which he would have if he were not also a general partner. And we will also discuss that when we talk about the rights of a limited partner as regards his contribution. Now, question. Can a partnership under paragraph 2 of 1767 be a limited partnership? If I may read it, the second paragraph of 1767, where two or more persons may also form a partnership for the exercise of a profession. And the answer is no. Because by the very definition, under paragraph 2 of 1767, the professionals exercise a profession. So necessarily, there is a contribution of their service. What must the contribution be made if they cannot perform services? Here, under 1844 letter F, if you remember, it can be cash, in which case in the certificate, you must state the amount. Or it can be property, but you must state the agreed value of the property. And please note that the term here that was used is contributed, past tense. What does it mean? It means that the limited partner must give his or her contribution before the formation of a limited partnership. This, however, does not restrict the limited partner from giving additional contributions later on. So, 1853, as I've already mentioned, we will discuss again later on when we talk about partners' liabilities. Let's talk about the management of a partnership, whether it's general or limited. So, for the management of the partnership, if you remember our discussion before, it's covered by 1803, 1805, 06, and 09. Where, if you remember, I will not really read it anymore. It's about the rules on management and the rights of the partners, like where the liabilities, like where the book should be kept, and that any partner can actually demand a full accounting from the general partner or the acting partner. So basically, the management of the partnership is under 1810, number 3, where each partner in a general partnership has the right to participate in the management. Excuse me. Now, with regards to the limited partnership, although the Civil Code does not have a provision particularly talking about a limited partner's ability to manage the business, 1848 indirectly shows that a limited partner is not allowed to do so. When you read it, a limited partner shall not become liable as a general partner unless he takes part in the control of the business. So when you read that, it just means that a limited partner is not allowed to manage the business. Otherwise, if they do, the limited partner becomes liable as a general partner. This is so that third persons are allowed to safely assume that the partners they are transacting with are general partners. It would be unfair to allow limited partners to have control of the business but be exempt from liability. So, because if you allow limited partners to be part of the business, then they can just make any rash decision, knowing that their liability stops with their contribution. Now, with 1848, when you say control, the word control right here, it does not mean liquidation. It means active participation in the management of the business. So, not included in control is the mere giving of advice to the general partners. They can make suggestions, especially since they are still partners, meaning they are also interested in the success of the business. Note that the bare grant of apparent authority to a limited partner, meaning to allow a limited partner to participate in the business, does not make the limited partner automatically liable as a general partner. What is needed is that limited partner actually participates in the control of the partnership. So there is an example given by De Leon, where he cited U.S. jurisprudence or a U.S. case, where a limited partner is liable as a general partner even if they did not participate actively, because these limited partners chose the group of people who will act. So or say when the limited partners appointed the directing manager of the firm, then in that case, the U.S. Supreme Court said that it was like they were already participating in the management because they had the power to appoint. Now, note also that a limited partner's restriction against managing the business does not mean that that limited partner does not have any rights. It also does not mean that they do not have the same rights as a general partner. There are some rights that both general and limited partners have. And these are under Article 1851. Yeah, see? So, a limited partner shall have the same rights as a general partner. To, number one, have the partnership books kept at the principal place of business. If you remember a while ago on the left side, it's 1805. Number two, demanding a true and full information of the things affecting the partnership. That's under Article 1806. And number three, have dissolution and winding up by decree of court. That is under Article 1809. And a limited partner shall have the right to receive a share of the profits or other compensation by way of income. That's under Article 1831 and 1857. Yeah. Before I go to the other rights of a limited partner, please take note that a limited partner may enter into transactions, meaning business transactions with a limited partnership. Therefore, while they are partners who contributed to the business, they can also act as creditors of the business. These allowable transactions are under Article 1854, which we will discuss later, as long as they are not also general partners. Note, if you remember, there are limited partners that have a dual role, limited general. So when I say that limited partners can transact with the business under Article 1854 here, you will see, this only refers to limited partners alone, not dual-rolled limited general partners. So what are these transactions? They may loan money and transact other business with the partnership. Meaning, if a partnership is for the buying and selling of cars, then a limited partner can be the supplier of the said cars. Now, even if they may have the role as a creditor or a supplier of the limited partnership, there are certain things that they cannot do because they are still limited partners. Like, they cannot hold as collateral any partnership property. Or number two here, they cannot receive from a general partner or the partnership any payment, conveyance, or release from liability if at the time the partnership assets are not sufficient to discharge partnership liabilities to others. So even if limited partners do have priority rights over general partners in terms of getting their contributions and payments, which we will discuss later on, they are still lower in terms of preference when it comes to third parties or third persons creditors. Now, if in the event they do receive collateral or payment in violation of numbers 1 and 2 of this provision, then it is considered as if they are doing it to defraud creditors. What is the reason for the prohibition? While limited partners have no right to participate in the management of the business, there is still a natural tendency for the partners to give preference to each other. That's why third persons are still given preferential rights over partnership assets. Now, we already mentioned this also in our previous video under Article 1827. Now, if for those who are reading De Leon, although again, I'm not requiring it, that's why I'm already discussing as much as I can, he gave an example where a limited partner is not prohibited from purchasing any partnership property, because if you look at number 2, it's not allowed. He said there that if the purpose is to generate cash which will pay off partnership obligations to third persons, then it's allowed. Because if you can tell from De Leon's example, it means it's actually contrary to the presumption that the limited partner is doing that to defraud creditors. By buying property to be able to pay the creditors, then it means that he's actually trying to help pay partnership debts. I will not elaborate more on that because there can be other arguments opposing De Leon's view. But since this is for board exam purposes and for accountancy students, then I will not get into further discussion about that. As to the management of the partnership, or more particularly the authority of general partners in running the affairs of the business, if you recall, under Article 1818, the things that the general partners can and cannot do are actually still applicable for limited partnerships. Now, under Article 1850, a general partner shall have all the rights and powers and be subject to all the restrictions and liabilities of a partner in a partnership without limited partners, meaning this first part of the paragraph refers to Article 1818. However, without the written consent or ratification of the specific act by all the limited partners, a general partner has no authority to do the following acts from numbers 1 to 7. So what does it mean when you say consent or ratification? If it's consent, then it's easy. It means that you need to get the express approval of the limited partner for a general partner to be able to do the acts under numbers 1 to 7. When you say ratification, it means that they are actually allowing it by, say, accepting the benefits of whatever these acts are. So I will not read this one by one. You can read it yourself. Take note that the limitations here apply even if the acts have been agreed upon by all the general partners, because the requirement here is the consent and ratification of the limited partners. These acts are acts of strict dominion or ownership and are beyond the general scope of agency given to a general partner under Article 1818. So numbers 1 to 4 here, they are prohibited because 1 to 4 are prejudicial to the limited partner's interests. Numbers 5 and 6 relates to the fiduciary nature of the partnership. Because a limited partner is still a partnership, the element of delectus personae, if you remember, the ability to choose your partners or who you want to be associated with, is still there. So you don't need to memorize the Latin terms. I'm just mentioning it, especially for those who want to take up law or those who are reading the book and have come across that term. And number 7, this is not allowed because this will result in the dissolution of the partnership. What are the other restrictions to a general partner's authority in managing the business? Number 1, they have no power or authority to bind the limited partners beyond the limited partner's investment. Number 2, they cannot act for the firm beyond the scope of the partnership, which I think is already self-explanatory as it's already stated in 1818 indirectly. And number 3, they cannot change the nature of the business without the consent of the limited partners. So, what are the rights? Limited partners' other rights. Cute na. Nicki Minaj. Under Article 1855, here, where there are several limited partners, the members may agree that one or more of the limited partners shall have the priority over other limited partners as to the return of their contributions, as to their compensation by way of income, or as to any other matter. If such agreement is made, it shall be stated in the certificate, and in the absence of such statement, all the limited partners shall stand upon equal footing. Meaning, although aside from the fact that a limited partner has priority over general partners, meaning they are less exposed to risk, and they can actually ask for a return of their contributions even before dissolution, which general partners are not allowed to do, the limited partners can actually agree on a hierarchy among themselves. But in order for that hierarchy to be in effect, it must be stated in the certificate. Otherwise, it is assumed that all limited partners are equal in terms of the return of their contribution, in terms of getting income or compensation, and by way of income, and in terms of any other matter that they want to agree on. Now, if you note that the term members here, members refers to, does not differentiate. So it refers to both general and limited partners. So the agreement must be between all partners of the partnership. Excuse me. Under Article 1856, another right of the limited partner is they may receive the share of the profits or the compensation by way of income, stipulated in the certificate, provided that after such payment is made, whether from the property of the partnership or that of a general partner, the partnership assets are in excess of all liabilities of the partnership except liabilities to limited partners on account of their contribution into general partners. Okay, before your eyes glaze over, let me just explain. A limited partner may receive the share in the profits as long as the assets of the partnership are greater than the liabilities. Okay, that's clear enough. Now, the last part of the sentence just talks about how you should compute partnership liabilities. When you say partnership liabilities, it refers to all liabilities except liabilities to limited partners on account of their contributions. Meaning, when you compute for liabilities, you include the partnership's liabilities to the limited partner acting as, say, creditor or supplier. If you remember in our previous article, they can transact business with a limited partnership. So you remove liabilities to a limited partner if it refers to the limited partner's contribution only. Now, another item that is removed from the computation of partnership liabilities are all liabilities to a general partner. There. In Article 1856, all this article means is that a limited partner has the right to receive his or her share in the profits, or what we call compensation by way of income, which share was agreed upon in the certificate, for as long as the partnership assets are in excess of the liabilities. This is in harmony with the requirement that a third-party creditor has priority over a limited partner's rights. So the exception stated therein only means, again, as I mentioned, in terms of the computation, what we will remove, the partnership's liabilities to a limited partner's contributions, and a partnership's liability to the general partner, whether it's for general partner's contribution or otherwise. Please note that partnership creditors still enjoy preference. So if you're talking about the partnership liabilities to creditors, third-party creditors, and partnership liabilities to limited partner creditors, then the third-party creditors enjoy preference. This is clearly stated in Article 1827, which we have discussed in our previous video. Another right of a limited partner is under Article 1857. So just take note of this right now because we will discuss this further when we talk about the return of a limited partner's contribution. To briefly summarize a limited partner's rights, I have written the 11 here. 1, to have the books kept in the principal place of business similar to a general partner's rights under 1851. Number 2, to inspect and copy the books, also under Article 1851. Number 3, to have on-demand true and full information of things affecting the partnership, under 1851 and 1806. Number 4, to have a formal accounting, again, 1851 and 1809. Number 5, to have a judicial dissolution and winding up, under 1831, 1851, and 1857. Number 6, to receive the share in the profits or other compensation by way of income. Please disregard my typographical error. Please note there's an asterisk here in number 6. It means that a limited partner has the right to receive his or her share in the profits or other compensation by way of income if the partnership assets are in excess of the liabilities, which I have already discussed how we will be computing partnership liabilities. No? Number 7, to receive a return of his contribution, and I have placed 2 asterisks here because we will discuss later that it can be generally demanded in cash, but it can also be demanded in other form of property. Number 8, a limited partner can loan money to the partnership, which a general partner cannot do. That's under 1854. Number 9 and 10, to transact with the business and to receive pro rata share in the partnership assets along with general creditors are also under Article 1854, which I have already flashed earlier. And number 11, to have priority over other limited partners on the return of their contributions, which I just mentioned in 1855. Now, let's talk about who may be a party in a case. Should a case be filed by the partnership or filed against a partnership? So in a general partnership, any partner can be a party to the case, meaning a partner can act on behalf of the partnership. That's why, if you remember in our discussion in the previous videos, we have rules on notice under 1821, where notice to the managing partner or a partner who could and should have communicated the information operates as notice to the entire partnership. Please don't be intimidated when I mention article numbers. You are not, again, required to memorize the article numbers. Personally, even if you plan to take up law, I only mention this because you might not be able to read the PowerPoint if it might be too small. So at least you can use it for your cross-reference or for further study. As regards a limited partnership, under 1866, a contributor, unless he is a general partner, is not a proper party to proceedings by or against a partnership, except where the object is to enforce that limited partner's rights against or liability to the partnership. So, in other words, if in a general partnership, any partner can go to court and act on behalf of the partnership, a limited partner cannot, if it is for the partnership. But, for example, there is a case filed against the limited partner for his share, then obviously, it's not a case against the partnership, it's a personal case against the limited partner. So, for obvious reasons, the limited partner will represent himself because he's already talking about his personal share. A limited partner is a mere contributor. He is practically a stranger in the limited partnership whose liability is limited to the interest of the firm. Since they are not principals, their liability is to the partnership and not to the creditors. I will repeat that. A limited partner's liability is to the partnership and not to the partnership creditors. Corollary thereto, a limited partner has no right of action against third persons against whom the partnership has any enforceable claim. So, because a limited partner's liability is to the partnership and not to the creditors of the partnership, a limited partner cannot run after the partnership's creditors. The partnership's debtors. I hope that's clear. Now, for 1853, a person, as I mentioned this earlier, this is regarding the dual nature of a general-limited partner. A person may be a general and a limited partner in the same partnership. And one who is a general limited partner at the same time shall have all the rights and powers and be subject to all the restrictions of a general partner, except that in respect to his contribution, he shall have the rights against other members which he would have had if he were not also a general partner. So even if a partner is a limited partner, they can be proceeded against. They can be a party in a case of litigation because they're general partner in that regard. What happens here is that a general limited partner has a limited liability only insofar as the other partners are concerned. Third parties can run after him, and they can ask that general-limited partner to pay using that general-limited partner's properties. Sorry, I'm using general-limited para easier to understand. While a limited partnership may engage in any form of business which a general partnership may enter into, it's a different playing field when we are talking about the types of business its individual partners may engage themselves in. So please note there's a difference between the business that a partnership may enter into and a business that the individual members of the partnership may enter into. Because a limited partner cannot participate in the active management of the business, as we have already discussed earlier, it would be unfair to prohibit them from engaging in other businesses, especially in cases where there's no conflict of interest on the part of the limited partner. So I have put here the previous provision under Article 1854 where a limited partner transacts with the limited partnership, because that's a form of business. So in my previous example where a partnership is buying and selling cars, and say I'm the limited partner and I'm the supplier of the cars, that's my other business, that's my hustle, that's why I put the GP there. Because a limited partner may engage in other businesses, his share in the business may be enforced in court by the limited partner's creditors, much like judgment creditors for general partners under Article 1814. Moving on to a partner's liability. Under general partnership, if you remember 1816, everyone is liable pro rata. Now, we move on to limited partnership because we have already discussed the liabilities of a general partner before. This is what is unique about a limited partnership. The liability is only to a certain extent. So before that, we go to 1845. A limited partner's liability is cash or property. They cannot contribute services. Please note 1844F, where the contribution must be made before the execution of the certificate of limited partnership. Sorry, I keep burping. And then 1847 is another liability of a limited partner. So if a certificate contains a false statement, one who suffers loss by reliance on that false statement may hold any party to the certificate liable. So anyone who knew that the statement was false. This does not say that the guilty partner, meaning the partner who caused the false statement to be in the certificate, shall be liable as general partner. This provision should not be construed to mean that a limited partner becomes a general partner even to third persons. If you read, please do read numbers 1 and 2 of 1847. So an example under 1847 is if a limited partner appeared as a general partner in the certificate, he is liable as a general partner when other general partners are insolvent. And then number 2, for example, this is actually De Leon's example from the book. A limited partner contributed 15,000 as per the certificate. However, A just really contributed 10,000 pesos. He is now liable to innocent third persons, meaning persons who relied on that statement for the difference of 5,000. In both examples, in the example where A is mistakenly named a general partner and the example where A failed to contribute the full 15,000, only gave the 10,000, A is not liable as a general partner. So, he is a limited partner with respect to his co-partners who knew of the certificate's falsity. When we go to 1848, a limited partner shall not become liable as a general partner unless in the exercise of his rights and powers as a limited partner, he takes part in the control. We have mentioned this earlier. Take note, the provision talks about control. It does not, that's why there's a letter X, it does not contemplate a situation where a partner participates in the liquidation. Because when you say control, it means the normal transactions of the business. His absence from participation in the transactions of the business is essential. That's why important itong 1848. His absence from the participation in the transaction is essential in order to exempt him from liability for the personal liability. The bare grant of apparent control, I have mentioned this already, bare grant of apparent control without the actual exercise of control does not make a limited partner liable as a general partner. And I think I mentioned it earlier, mere giving of advice is allowed. That's not control. A limited partner can suggest or express opinions. So I've mentioned that already. Now let's move on. Under Article 1852, and I've mentioned this earlier, but I will go through this again because this is properly for a partner's liability. Please note that the term person was used, meaning does not have to be a partner. If a person who has contributed capital to a business erroneously thought that he became a limited partner, he is not a general partner. Therefore, he is not personally liable. As long as that person who erroneously gave money thinking he's a limited partner immediately renounces his interests in the profits or income of the business as soon as he finds out that mistake. This is a unique article because this is an exception to 1844. If you remember, under 1844, a limited partnership must conform to the formal requirements stated therein. Failure to comply with the formal requirements, except if there's substantial compliance, results in the formation of a general partnership. Therefore, if the limited partners fail to comply with 1844 or there is no substantial compliance, everyone is liable as a general partner. So going back, because of this 1852 article, even if there is no compliance or there is no substantial compliance, a limited partner does not automatically become liable as a general partner as long as that limited partner promptly renounces his interest in the profits of the business or other compensation. Number 2, as long as his surname does not appear in the partnership name. I'm correlating this to the previous article. And number 3, he does not participate in the management of the business. What does it mean when you say renounce? Again, it means that the limited partner sells his or her interest to the general partners before the partnership becomes liable to third persons who considered him a general partner. That's why there was the term promptly renounces, because the minute that a third person already relied upon this certificate, then the limited partner becomes liable as a general partner. Because again, this is for the protection of third persons. This article also contemplates situations where the certificate of partnership complies with the formal requirements of 1844, but 1, a limited partner's name appears in the certificate as a general partner. Kasi if you remember, if a limited partner's name is stated in the firm name, then he becomes liable. So if the limited partner, for example, I'm a limited partner, I find out that my name is there, as soon as I find out and I renounce that, I have it amended, then I will not be liable as long as no one relied upon it, a third person. And number 2, a limited partner is not designated as a limited partner because if you look at 1844D, it must state who the limited partners are. So again, if I am a limited partner and I did not know that my name was not listed as a limited partner in the certificate, as soon as I find out, I can renounce my share, I can sell it. As long as no one has relied upon that certificate yet, I will not be liable as a general partner. So, if I may go back to the word persons, which I encircled there, in another book I'm reading, it stated that, again, this article also applies to cases where a person advances money to a limited partner, but that person is not a partner. It covers all cases where one has contributed to the capital of a partnership. Now, Article 1853. Although we have discussed this in terms of how a third party may proceed against a dual-role general-limited partner, I just want to clarify that a general-limited partner is liable with his separate property to third persons following Article 1816 and can exercise the rights of a limited partner just as against his co-partners. And we will discuss this later on under Articles 1855 to 1858. Briefly, I will just mention 1855 relates to the right of a limited partner to have priority over other limited partners. Oh, we have already discussed this a while ago. When we go to other liabilities pa, so I just put the other liabilities of the general partnership on the left. We've already discussed that. Article 1846 is self-explanatory and we have already discussed this when we talk about the firm name. Article 1858. Now, this is important. A limited partner is not liable to the partnership's creditors. I have mentioned that already. Because a limited partner is only liable to the partnership, there is a difference. They are not liable, as again, they are not principals in the partnership's transactions. So in 1851, a limited partner is liable to the partnership, number 1, for the difference between his contribution as actually made and that stated in the certificate. If you remember De Leon's example, a limited partner was supposed to contribute 15,000 as stated in the certificate, but he only contributed 10, so he's liable for the difference of 5. And then number 2, for any unpaid contribution which he agreed in the certificate to make in the future on the condition at the time and conditions stated in the certificate. So again, while a limited partner is supposed to give his initial contribution even before the limited partnership has been created, a limited partner may give after additional contribution. In that case, when that time or the conditions stated in the certificate have been fulfilled, that limited partner will be liable to comply with what's stated in the certificate. Now, next paragraph. A limited partner holds as trustee for the partnership 1. Specific property stated in the certificate as contributed by him, but which was not contributed or which has been wrongfully returned. Number 2. A limited partner holds as trustee for the partnership money or other property wrongfully paid or conveyed to him on account of his contributions. So, second paragraph contemplates 4 situations. A limited partner is a trustee for 1. Specific property stated in the certificate that was what he promised to contribute but he did not contribute. 2. Specific property that's stated in the partnership which he was supposed to contribute but was wrongfully returned to him. Number 3, money wrongfully paid or conveyed to him on account of his contribution. And number 4, other property wrongfully paid or conveyed to him on account of his contribution. The liabilities of a limited partner as set forth in this article can be waived or compromised. But a waiver or compromise shall not affect the right of a creditor of a partnership who extended credit or whose claim arose after the filing and before a cancellation of the certificate to enforce such liabilities. So, if I may use De Leon's example for this third paragraph, using the example a while ago about the 15,000 contribution of the limited partner, let me add, if A promised or is stated in the certificate that he will contribute 15,000 but he only contributed 10. And then number 2, B, also a limited partner, promised to give additional contribution of 2,000 at a certain date. Their failure to the failure of A to give the 5,000 difference and the failure of B to give the 2,000 upon the arrival of a certain date stated in the certificate, these liabilities of A and B can be waived, but it must be with the consent of all partners. If ever, for example, there is a waiver, but X decides to extend credit to the partnership after the said waiver, if there is no amendment to the certificate stating na, A's contribution is just 10, not pala 15, and B's contribution, B will not have any more an additional contribution. If the certificate is not amended to reflect what really happened, meaning the amount that A gave, 10,000 only, X can still enforce the 2,000 from B and the 5,000 from A. Because even if X extended credit after the liabilities of A and B are waived, X, at the time that he extended credit, can safely rely on the certificate that states that A contributed 15, B will give 2,000 at a certain date. I hope that's clear. Now for paragraph 4, when a contributor has rightfully received the return in whole or in part of the capital of his contribution, he is nevertheless liable to the partnership for any sum not in excess of such return with interest necessary to discharge his liabilities to all creditors who extended credit or whose claims arose before such return. What does it mean? If, in the example, A limited partner, gave 10,000, if A lawfully received the return of his 10,000 contribution on the date stated in the certificate, because as I mentioned earlier, a limited partner, unlike a general partner, may actually seek a return of his contribution before dissolution, as long as it's stated in the certificate. So if A lawfully received the return of his 10,000 contribution, and the partnership is liable to X, A's liability would depend on when X extended credit to the partnership. Okay. If X extended credit after the date stated in the certificate and the partnership's assets are insufficient to pay partnership debts, then X can claim from the general partners. But if X extended credit before that date, the date stated when A can get the return of his 10,000, then A is liable to the partnership, so the partnership can use that money to pay X. Therefore, A's liability to the partnership shall only be to the amount of whatever he received, 10,000, plus interest on the 10,000. So why is it that under the first scenario, meaning when X extended credit after, why is it that A cannot be made liable to return the contribution he received? Because the certificate indicates that A can already get back his money at this date. Therefore, third persons who want to extend credit are presumed to know this fact. Because again, filing with the SEC is considered constructive notice to the world, so they're supposed to read the contents of that certificate of partnership. Summarize, a limited partner's liabilities are the ones stated here, the 7. Number 1, not to allow the inclusion of a limited partner's surname in the firm's name. Please note the exceptions under Article 1846. I mentioned earlier, unless it is the surname of a general partner, or unless the business had been carried on under that name prior to the limited partner joining. And then number 2, a limited partner is liable as a general partner if he takes part in the control of the business under 1848. Number 3, he is liable to the partnership for the difference in his actual contribution or any unpaid additional contribution. Please disregard this letter A. We have discussed this. If you remember, this is the example of A contributing 10,000 when the certificate stated he was to contribute 15, and then B was to contribute an additional amount at a certain date as stated in the certificate. This number 3 is under Article 1858. And then number 4, to hold as trustee specific property, money, or other property. I mentioned the 4 instances. And Number 4 is subject to waiver or compromise. That's why there are 2 asterisks there. Number 5, to be liable for any sum he rightfully received as a return of his capital, which is necessary to discharge a partnership liability. Again, this is under the conditions under Article 1858. Under Article 1857, Paragraph 1, which we will discuss later, a limited partner may claim his contribution if all members consented to the return of contribution and the certificate is amended or cancelled to reflect such withdrawal, if the partnership assets can sufficiently cover the partnership liabilities. However, for example, when at the time that the limited partner will withdraw his contribution and again the partners consented to it and it was reflected in the certificate, if after the withdrawal the partnership's assets suddenly become insufficient, say for example the assets suddenly were destroyed, so the value was decreased, probably became zero, no? Then a limited partner may be liable to return the amount he withdrew plus interest. That was the one that I just discussed earlier also. And the number 6 and 7, the liability not to hold as collateral partnership property and not to receive property on account of his claims. This was discussed a while ago under Article 1854. Let us move on to the assignment of interest. If you remember, in general partnership, that's under 1804, 1813, and 1814. 1814 is the charging order, if you remember the drawing of the bull. So for limited partnership, it is covered by Article 1859. A limited partner's interest is assignable. A substituted limited partner is a person admitted to all the rights of a limited partner who has died or who has assigned his interest in a partnership. So, an assignee who does not become a substituted limited partner has no right to require any information or account of the partnership transactions or to inspect the books. Therefore, similar to general partnership, an assignee does not automatically become a partner. Here, he is only entitled to receive the share of the profits or other compensation by way of income or the return of the contribution to which the assignor is otherwise entitled. So it's similar to a general partnership where the assignee does not have the rights of a partner except the rights of the original partner to receive profits. And here in this case, because a limited partner can have the return of his contribution ahead of time, then that assignee also has that right. So an assignee shall have the right to become a substituted limited partner. So this is a new term, unique to a limited partnership. It was mentioned here in the second paragraph, a substituted limited partner. And in the third paragraph, in the third paragraph, it states when an assignee becomes a substituted limited partner. It says here, if all the members consent. When you say all members, it means you're referring to both general and limited partners. Or, if the limited partner assignor is allowed to get a substitute, as stated in the certificate. So when does a third person become a substituted limited partner? When the certificate is appropriately amended in accordance with 1865. Why? Why is it upon amendment? Again, a certificate filed with the SEC operates as constructive notice to the world. So until that certificate is not amended and the amended certificate is not filed with the SEC, then the whole world can safely assume that whatever is with the SEC, the old one still applies. So a substituted limited partner has all the rights and powers and is subject to all the restrictions and liabilities of his assignor, the original limited partner, except a substituted limited partner is not liable for liabilities that substituted limited partner was ignorant or did not know at the time he became a limited partner, in which it cannot be seen from the certificate, cannot be ascertained. The substitution of an assignee as a limited partner does not release the assignor, the original, from liability to the partnership under Articles 1847 and 1858. If you remember, 1847 refers to instances when there is a false statement in the certificate. Diba? The limited partner must promptly if you remember, under Article 1847, if a certificate contains a false statement, any party may be liable if that party knew that the statement was false, and he will be liable to anyone who relies on this false certificate. And then under Article 1858, that is when a limited partner is liable for the difference of his contribution, for any unpaid contribution that he promised to give later on, he's also liable for specific property, money or other property that was wrongfully returned to him, which we discussed earlier, no? The ones that can be waived. Yan. So, even if a limited partner assigns his rights to a substituted limited partner, the original limited partner is not completely off the hook. He will not be released from liability under 1847 and 1858. So, what is the importance of this 1859? Because of the ability to substitute a limited partner, a partnership is not necessarily dissolved because of a limited partner substitution. It also means that a limited partnership is not dissolved because of the limited partner's withdrawal, death, insolvency, incapacity, civil interdiction, or even if the partners were to add another limited partner. This is not the same when it comes to a general partnership. If you remember, a general partnership is automatically dissolved if one of the partners dies, withdraws, becomes insolvent, blah, blah, blah. Not so with limited partnership. Note, and I cannot stress this enough, that the assignee becomes a substituted limited partner upon the compliance of 3 requirements. 1, consent of all the members, or if it's stated in the certificate that the limited partner can assign his rights. Number 2, the certificate must be amended in accordance with 1865. And number 3, the amended certificate must be registered with the SEC. As to the charging order, for general partnership is under Article 1814. Now for limited partnership, it's under Article 1862. On due application of a court, the creditor of a limited partner may charge the interest of the limited partner to pay for that claim, the creditor's claim, and the court may appoint a receiver to do whatever that needs to do so that that will happen. The interest that is charged, meaning the limited partner's interest in the limited partnership, may be redeemed with the separate property of any general partner, similar to here on the left side, but it cannot be redeemed with partnership property. So to be clear, for a general partner's judgment creditors can get his share in the interest, which may be redeemed by partnership property. But for limited partners, once his share in the interest is already taken by a judgment creditor through the help of the court, redemption can be done by a general partner, but not using the partnership's property. The remedy of a judgment creditor for a general partnership under 1814 is exclusive, meaning for if you are a creditor of a general partner, your only remedy to get the share of the general partner is through 1814. But if you are the creditor of a limited partner, you also have other remedies, because 1862 states that the remedies is not exclusive if there are other remedies that may exist. So right now, I can't think of any, no? happens when a limited partnership is dissolved? The prints are too small, but please do remember dissolution for a general partnership was covered or is covered under Articles 1830, 1831, what else? And Judicial dissolution in our previous video. Just please go back to it. Let's dive straight into the dissolution of a limited partnership. Under Article 1860, the retirement, death, insolvency, insanity, or civil interdiction of a general partner dissolves the partnership unless the business is continued by the remaining general partners. And the business can be continued by the remaining general partners if there is a right under the certificate to continue, or if all the members, limited and general partners, consent to the continuation of the limited partnership. Now, please note that a dissolution of a limited partnership happens only if we're talking about the general partner's retirement, death, insolvency, insanity, or civil interdiction. I said it fast because it's right here. If a limited partner dies, becomes insolvent, becomes insane, or is adjudged with civil interdiction, penalized with civil interdiction, then the partnership is not dissolved. It's obvious. Now, be careful. If there is one general partner and one or more limited partners, if the general partner dies, obviously, the partnership cannot be continued. Why? Because 1860 states that the business can be continued by the remaining general partners. Okay, another note. If there are, say, two general partners, if there are if there are two general partners, at least two general partners, and one limited partner, and the limited partner dies, obviously, there is no more limited partnership by the definition under 1843. Because if the limited partner dies and there are two general partners remaining, what do you think is left? General partnership. So, let's continue. If the partnership is continued by the remaining general partners, please note the requirement under 1864, paragraph 2, number 5, and we will discuss this later, that the certificate must be amended. Okay. Now, 1861. On the death of a limited partner, his executor or administrator shall have all the rights of a limited partner for the purpose of settling his estate. So, the executor has all the rights, but only to settle the estate. And such power as the deceased has to constitute his assignee a substituted limited partner. What does this mean? And such power as the deceased has. If you remember, when we were talking about substituted limited partner, he can do so if it's stated in the certificate that a limited partner can make an assignee a substituted limited partner. Okay, so the estate of a deceased limited partner shall be liable for all his liabilities as a limited partner. What does that mean? The last paragraph simply means that everything that happened until that limited partner dies, even if it's not paid, if it's not paid after the death, as long as it was incurred before the limited partner's death, then the estate will answer for it. Now, I'm sorry that the print is extremely small. This is Article 1857. So for those of you who want to go along and the print is too small, I uploaded a copy of the codal provisions, the civil code in relation to law and partnership in our Canvas account. Okay, so I'll continue. What I did, I just placed the paragraph numbers here because it's a bit confusing if you read the law just straight. Now, a limited partner shall not receive from a general partner or from the partnership property any of his contributions except in 4 instances. In paragraph 1, he can receive his contribution if 3 conditions are met. Number 1, all the liabilities are paid or the partnership's assets are enough to cover these liabilities. And please recall how we compute partnership liabilities from the start of this video. We remove the liabilities to the general partners and the liabilities to the limited partners for their contributions. That's not included in the computation of partnership liabilities. Number 2 condition, all members must have consented to the return of the limited partner's contribution. Number 3, the certificate is cancelled or amended to show that the withdrawal or the reduction of the limited partner's contribution was made. This is required because, again, the certificate with the SEC operates as notice to the world. Okay, so let's move first to, let's use the example of De Leon for paragraph 1. I took a picture. I didn't want to type it. After operating for some time as a limited partnership, X and company composed of ABC as general partners who gave 30,000 each, and DE as limited partners, so there are 5, 3 general and 2 limited. And the 2 limited partners, D and E, contributed 20,000 each. If that partnership has total assets of 150,000 and have the following liabilities stated here, may E, a limited partner, legally demand the return of his contribution, assuming that all the partners gave their consent and are willing to have their certificate amended. So this example means, this is for paragraph 1. Can the limited partner ask for a return of his contribution assuming number 2 and number 3 are complied with? How do you compute? Now, I already put a check mark here. The answer is yes, he can claim. Why? Because, again, the total assets are 150,000. What is the partnership liability following the computation I mentioned at the start of the video? You will not include as partnership liability the limited partner's contribution. So this is not included. Number 1 is not. The loan extended to C, because C is a general partner. That's not a partnership liability. And indemnity to B for damages suffered as a consequence of management. That is not also a partnership liability. So what are the partnership liabilities? Those due to other creditors, 50,000. Loan extended to limited partner D for 35,000. And taxes for 15,000. Adding these 3, number 2, 4, and 5, this is 100,000. It is definitely, the total assets of 150,000 is definitely more than the 100,000 liability. Therefore, E can claim for the return of his contribution. So while paragraph 1 necessitates a computation as mentioned here in the illustration, paragraph 2 talks about a limited partner's right for the return of his or her contribution. So subject to the provisions of the first paragraph, a limited partner may rightfully demand the return of his contribution. Number 1, if the partnership is dissolved. 2, if the limited partner is allowed to get the return of his contribution as stated in the certificate, and that date already arrived. And number 3, after he has given 6 months notice in writing to all other members, if there is no time specified on the date, or either for the return of the contribution or for the dissolution of the partnership. Paragraph 3, in the absence of any statement in the certificate to the contrary or the consent of all the members, A limited partner, irrespective of the nature of his contribution, has only the right to demand and receive cash in return for his contribution. So the limited partner generally cannot say, you know what, instead of, for example, if I may go back, diba, here in the example, the question was, can E demand a return of his contribution? How much did he contribute? 20,000. Since the total assets is 150,000 and partnership liability is only 100, then he can claim for the 20,000. Under paragraph 3, E cannot say, instead of cash, can you just give me inventory of the partnership worth 20,000? The answer is no. Generally, he cannot, except if it is stated in the certificate that a limited partner can receive other property and not necessarily cash, or all the partners, general and limited, consented to E's receipt of other property in lieu of his 20,000 contribution. Now, paragraph 4 contemplates judicial dissolution, which is similar to 1838 of general partnership, if I remember correctly, if it was the one flashed a while ago, no? Limited partner may have the partnership dissolved and its affairs wound up when he rightfully, number 2, no? If he rightfully but unsuccessfully demands the return. So in this case, he is allowed to get 20,000, but they don't want to give it to him. Then he can ask for the court's help. Or number 2, the other liabilities of the partnership have not been paid, or the partnership property is insufficient, and the limited partner would otherwise be entitled to the return of his contribution. Note that before a limited partner goes to court to have the partnership dissolved, it's logical first that the limited partner asks the other partners before he runs to court. Because, for all you know, the partners might actually consent to the dissolution in the first place. It's expensive kasi to go to court, and aside from the fact that it will take a lot of time. After we have talked about dissolution, then necessarily we will talk about liquidation. If you remember the part of the previous video where I had several jiffies on the left, and I was removing what would be paid first, say the liabilities of the partnership in the rank from creditors other than partners, etc., etc. That is the one under 1839 here on your left. Please do take time to read 1863 on the right. I will not read it out loud anymore. Just note that under 1863 number 1, creditors include limited partners as creditors, because remember, they are allowed to extend credit to the partnership under Article 1854. So just be careful. Unlike in the liquidation of a general partnership, when liquidating a limited partnership, the claim of general partners with respect to their share in the profits enjoy preference over their claims in respect of their contribution. So unlike in the liquidation of a general partnership, what goes first is the contribution and then the profits, if there are any remaining. In a limited partnership, the general partners first get their profits before their contribution. Now, after the liquidation, the next question would be, can there be a continuation of the partnership? And yes, there can. So if the continuation under a general partnership is covered by Article 1837, which you see to the left side of the PowerPoint, the one for limited partnership is under Article 1864. Article 1864 is actually self-explanatory. If you will observe, the instances necessitating the amendment of the certificate of a limited partnership are normally instances that lead to the dissolution of a general partnership. So what is the effect of the failure to amend the certificate? Well, it would seem that the limited partner will be liable as a general partner for failure to comply with the formal requirements. Because, again, a limited partnership is a formal contract. So if you fail to comply with it, then we will go back to the general presumption that the partnership is a general partnership. So, Article 1865 talks about what must be done when you amend a certificate. So, it's fairly straightforward. Just please read it na lang by yourselves. So, you can just make your own bullet points if you want to briefly summarize 1865 because it talks about the requirements for amending a certificate and the remedies of a person with the court if the person who must execute the certificate refuses to do so. Just be careful that 1865 talks about amending the certificate and filing it with the Securities and Exchange Commission. Therefore, the approval of the SEC is not required, okay? Just be careful with that. If we continue the limited partnership, it's possible also that they will add additional members. Actually, it can be done under Article 1849, even without the dissolution or liquidation. I did not anymore put the provisions for general partnership because I've thoroughly discussed this in a previous video. Now, for limited partnership, after the formation of a limited partnership, additional limited partners may be admitted upon filing an amendment to the original certificate in accordance with 1865. Now, although I did place this after liquidation, it does not mean that limited partners may only be admitted after liquidation. Okay, it can be at any time after the formation of a limited partnership. And the last article, I'm so excited, is for previous limited partnerships. Under Article 1867, a limited partnership formed under the law prior to the effectivity of the Civil Code may become a limited partnership under this chapter if they comply with the formal requirements under 1844. Okay, I will not discuss this. Why? Because the Civil Code, it's actually called the New Civil Code, took effect on August 13, 1950. Okay, my parents were just 3 years old then, and since I am older than you, I can only imagine that I can only assume that your parents were not yet born then. What does it mean? That means that if there is a partnership that subsisted before August 30, 1950, I think it would be safe to assume that the partners have already moved on to the afterlife. So this is not really such an important provision. After everything that's been said and done, with the restrictions of a limited partners, with the restriction on a limited partner's liability, one may be led to ask, why form a limited partnership in the first place? So, for the general partner, it is to secure capital from another person for their business. But, ang maganda doon, the general partner retains control. That's why a limited partner is actually like a stockholder. Like lang, because in corporation, a stockholder has control. Whether it's minority interest or majority interest, no. But again, in a limited partnership, the beauty about it is a general partner who needs cash can actually entice someone to be their partner while at the same time retaining control of the business. And what's in it for the limited partner? The limited partner shares in the profits without risk of personal liability. So in other words, it encourages those having capital to become partners with those having skill. that's it guys. We did it. Ang hirap pala mag-video. As you can see on the upper left, it was early before and it's not early now. So what is left? Guys, what's left is to study. But good luck and you can do it. That's my handwriting, so sorry chicken scratch. And I will see you for law on private corporations. I will upload the quiz on Thursday during our class schedule. Please do not cheat, and I will also upload a sample quiz during the weekend so you can study. On Tuesday, we will not have a synchronous class, but I will open my Zoom and be on standby in case anyone has questions. For those of you who will not be able to join Zoom because you would want to watch the videos again, that's okay, because all the questions that will be asked either through FB, email, or Zoom, I will also type down for everyone to know. So thank you everyone, good luck, God bless, and good night.